Hello everyone, I'm Anuj Jaggi and I'm a legal intern with LEXIS and Company, and the topic for today's second video presentation is void agreements. So section 2 clause G of the Contract Act, apart from those void agreements, the acts declares the following types of agreements as void. First being agreement in restraint of marriage, which is given under section 26, agreement in restraint of trade, section 27, agreement in restraint of legal proceedings, section 28, agreement void for uncertainty, section 29, agreement by way of wager, section 30, and agreement to do impossible acts, which is section 56. So agreement in restraint of marriage, which is given under section 26, is given under section 26 is in restraint of marriage if its object or effect is to restrain or prevent a party from marrying any person, or which is deterrent to marriage in so far as it makes any person uncertain whether he may marry or not. Such an agreement is void. For example, a contract not to marry any person other than the party to it was void on the ground that if that particular party had chosen not to marry, then the promisor would be restrained from marrying at all. Similarly, a contract that the plaintiff would not marry within a certain time would also be void. Restraint may be general or partial, and an agreement restraining marriage of minor is valid. And another case where a case where a condition in a waqf that if the widow remarried, she should forfeit her right to the profits under the waqf was accordingly upheld. A contract in general restraint of marriage is not enforceable on the ground of public policy, whether it contains an express undertaking that the subject will not marry, or whether on financial or other grounds it tends to discourage a subject to marry. Every agreement in total restraint of the marriage of any person other than a minor is void. Then the agreement in restraint of trade under section 27 is an agreement restraining a person from carrying on a lawful profession, trade, or business is void to that extent. However, an agreement not to carry on within specified local limits a business similar to the business of which goodwill is sold can be enforced, provided the limits of the restraint are reasonable. Although such kind of agreements are commonly found in two types of contract, which are the sale of goodwill of a business or the professional practice and contracts of employment, the categories of restraint of trade are not closed, and the principles are applied to a wide variety of other similar relationships. And keep in mind that such agreements are against public policy. So further moving ahead, the exceptions under this were also the sale of goodwill and the partnership under the Partnership Act, under which the partners of a firm may restrict their mutual liberty to do any trade other than within their firm. Further, a landmark case under this was the Gold Papers Mills versus Ganesh Das, under which apprenticeship for 20 years held unreasonable, hence void. And it was valid but void after a term of employment was ultimately over. And the agreement in restraint of legal proceedings, which is under section 28. This section rendered the following kinds of agreement void. The first one being an agreement by which a party is restricted absolutely from his legal rights arising under legal proceedings. Second, an agreement which limits the time within which the contract rights may be enforced. Third, an agreement which extinguishes the rights of any party or discharges any party from any liability under any liability under it, and in respect of any contract at the expiry of a specified period, so as to restrict any party from enforcing his rights. An agreement by which a party is restricted absolutely from taking usual legal proceedings in respect of any rights arising from a contract. This can be understood by the case of Musaji Lukman versus Durga Das, in which parties can choose one of the two tribunals for disposal of the case, and which was upheld by Supreme Court in Hukum Singh versus Gamon India Limited. Stipulation that the decision of arbitrator shall be final and conclusive, held void since it bars the jurisdiction of the court. Agreement conferring jurisdiction of the court agreement conferring jurisdiction on court not having jurisdiction is opposed to public policy. So this was the basic idea and the general concept of void agreements, and I hope I was able to give you a clear picture of this. And if you have any kind of doubts or queries, please feel free to drop them in the comment section. Thank you.